So the case comes out on the 30th. We have the welcome ceremony on Friday, July 24th. That's going to be on Zoom. And the reason we do that, we make that mandatory, is for two reasons. One, I want everybody to wear their t-shirts and we can take a group photo. It'll be a different kind of group photo, but it's going to be a group photo. And maybe with some Photoshop, I can put you all on the beach. But even more importantly, I want to make sure that we're all on the same page about the rules of the competition, the expectations for the competition. And I know we're doing rules discussion now. I have a feeling, though, that once you actually get the case and you start getting into it, you'll start to realize you have more questions than you do right now. So the competition weekend begins that Friday. Round one is that Saturday morning. We're going to have 3 rounds on Saturday. Rounds 1 and 2, you will play an attorney in exactly one of those rounds, and you'll play a witness in the other. And you're going to switch sides. So if you're a prosecution attorney in round 1, that means you'll be a defense witness in round 2, and vice versa. Round 3, we pair based on the results of rounds 1 and 2. We pair it high-high. And then round 4 is also paired high-high. You can be assured that you will play each of the 4 main roles once during those 4 trials. So you'll be a prosecutor once, a defense attorney once, a prosecution witness once, and a defense witness once. And I'm saying prosecution to mean both prosecutor or plaintiff. We haven't announced yet whether this year's case is criminal or civil. After the 4 preliminary rounds, we'll see which students have the top scores. The top 4 will advance to the semifinals. And then we have the award ceremony and the finals that afternoon, which we plan to live stream. So that's our format for the weekend. You can see before each trial, there's an advocates meeting and a witness prep session. Now, historically, we've done the witness prep and then the advocates meeting. Here, we're flipping it, right? So you can see in our rule book, witness prep sessions are going to happen first. And the reason is this way we don't have to pull you into breakout room and then send you back out and then pull you back in. So we're going to have you do your witness prep session 30 minutes before the trial, and then we'll do the advocate meetings. The advocate meetings are usually really short. In fact, sometimes it's just taking roll, answering a question, and we're done. The reason we do them is to make sure that if something comes up unexpectedly during the tournament or something needs clarification, it's the one way that I can make sure I can communicate with everybody at once. So that's the purpose there. Any questions about the schedule before I turn to the rules for online competition? Fantastic. Okay. So we're looking at the rules for online competition. This is page 7 of your rule book. And you can see section 9 begins. This section applies when and only when the trials occur online. To the extent this section conflicts with sections above, this section controls. In other words, it's not saying ignore everything else. Most of those rules are still in effect. You're still going to have direct examination. You're still allowed to raise objections, etc. But where this imposes different rules or additional rules, this controls if there's any conflict with the other rules. That way we didn't have to rewrite the entire rule book. We just focused on what's different. Section B says the host will coordinate all trials and Gladiator meetings by Zoom. I know you all know how to use Zoom because you're using it now. There's going to be a single Zoom login for the entire tournament. So some online competitions have had separate Zoom links for each trial, right? Depending on which trial you're in, you're going to follow a different link. The reason we're not going to do that is I want to be able to jump into every trial and make sure that things are running smoothly. And so everybody's going to sign into a single Zoom link. And I, along with one of our tournament volunteers, who I'll introduce in a moment, are going to assign you to the breakout rooms for your particular trials. Sue, do you want to pop on screen for a second and say hello?
Sure. Hi. I'll be helping Justin with this. I've helped in person in the past, and I'm happy to help this time. So,
Sue Johnson is tremendous. Many of you will recognize her from Empire fame when she made the impossible look not only possible but easy. She organized tons of trials and judge assignments, pairings, etc. She's helped us with Gladiator before. She's now on the board of directors for the American Mock Trial Association. She is the director of forensics at Patrick Henry College in Virginia, and she is a whiz. So I like to think I'm decent with Zoom. She is a Zoom master. So she's going to be helping us get everybody assigned to their breakout rooms. Any questions about what that means when I say breakout room? Anybody not know what that means? Great. So a breakout room is essentially a sub room of the Zoom room. So right now we're all in the same Zoom meeting and we're all able to see each other, hear each other. But suppose we wanted to have separate conversations. Zoom allows you to create smaller rooms and then send people to those rooms. And so if I'm in courtroom A, you can name the courtrooms wherever you want. So if I'm in courtroom A and Rachel Bays, who I see on my screen, is in courtroom B, I can't hear Rachel, Rachel can't hear me, our chats don't go to each other. And so we're able to use those as separate courtrooms. In a way, it's a lot like turning the Zoom meeting that we're in right now into the courthouse. So imagine we're all in the courthouse lobby right now, but each of those breakout rooms is a different courtroom. Does that make sense? Give me a thumbs up, somebody on screen, if that makes sense. Excellent. Okay, and Victoria, that is an adorable dog in the background. Okay, well, that's probably the best thing about Zoom is I get to see people's pets. Okay, so before trial, we talked about we're doing the witness prep sessions first. Those can start 30 minutes before the trial time. Obviously, this is one of those things that I can't enforce as a host. I can't prevent people from starting their witness prep sessions early. One way we try to curb it is we don't release the pairings of who's directing whom until a little bit before the witness prep sessions, but there's an honor code here. One of the things that I found competing online is that if people want to break rules, they can, but I haven't seen anybody do it. I haven't heard of anybody doing it. I think that one thing that's really cool about a competition like this is that you all are the best of the best. You're competitive, and that means you want to win, but you also want to win fairly. I have relationships with a lot of your coaches. Your schools have come back multiple times to the event. And so to those of you who are new, wondering how we're going to enforce these rules, I think the honor code, you're going to be surprised, is incredibly effective because the people at this event take it seriously, but they also take the civility and sportsmanship seriously too. So the witness prep session is still capped at 15 minutes. One rule we've changed this year is that you can take materials with you after the prep session. So suppose that Victoria, who I see on screen, is my witness. I can share with her the direct examination I'm going to do, and she can keep that outline. I can share it with a Google document. I can email her a Word document or a PDF. I can do that, and she can have that during the trial. There's nothing in the rules that prevents that. You may want to think strategically about whether you want to do that, because maybe Victoria's my witness in round one, but in the semifinal, what if she's my opponent and now she's got my script? So you can send your entire material to somebody that you're directing. You can be more selective about that. That's a choice you get to make. We're not going to coordinate those witness prep sessions for a couple of reasons. One, it's one more thing that we can put on your plate, not have to worry about with the technology. But the other reason is different people are going to want to do the prep sessions differently. Some of you are going to want to do it by phone, some by Zoom, some by Skype. Whatever you want to do is totally fine. This means, though, that when you sign on, you get your advocate meeting, and then you go right to your courtroom. So there's no other third step. Any questions about what those witness prep sessions look like, what's involved, how that works? You just send me a message in the chat if you have a question there. Great. Since I'm not seeing any questions, I'm just going to assume I've been phenomenally clear. Okay. We then are going to assign the gladiators and their second chairs and their coaches to the courtrooms. The reason we're limiting every team to 3 accounts per trial is to make sure that we're not overloading Zoom. I don't think we're going to get close to the cap, but I know that if everybody was allowed to invite their parents and grandparents and their cheering sections, then I think we would start to get close to the cap, and Zoom would be slower. You have connection issues. So as much as possible, we're going to try to record trials. I can't guarantee we're going to be able to record every trial. We'll do as much as we can. But in a trade-off between giving you great trials versus everybody being able to make sure everybody at home can watch, we're emphasizing, at least in our first time doing an online competition, making sure the trials run smoothly. Good question just now. Are witnesses allowed to have the outlines open during their directs? The person says, sorry if this is a little too late. First of all, there's no time limit here. So if I move to another topic and you have a question, I'm not going to say, question is overruled, your question's untimely. It's not going to work like that. So great question, I appreciate it. Are witnesses allowed to have the outline open during their directs? The answer is yes, you can. There's nothing that prevents you from doing that. Now you might say, well, that's not realistic. Witnesses can't have notes on the stand in court. That's true, but that's because court, we think of, takes place in person. As more and more litigation is happening online, whether it's trials or hearings, those rules and norms change. I know somebody who's doing a murder trial online right now. So the norms of what you can expect change when things are online. But what I would say is, if you plan on having your outline open or your script open during the direct, and it looks like you're reading back and forth across the screen, judges are going to notice that. The competition we went to where students were just reading their material, they thought, oh, I don't need to memorize. It's right there in front of me. The judges can see your eyes scanning, and you get marked down if it looks like if you're on notes. Okay, so trial procedures, 3 per room. We're only going to assign 3 people per team per room. And we want you to change your screen names when you get to your courtroom or when you finish your advocates meeting. So the example in the rule book is it's Caitlin Rice versus Anna Claypool, government counsel, defense counsel. And the witnesses should just use the witness name, government witness, defense witness, because that's what the score sheet's going to say. You don't have to worry about the judges getting your name right. Everything's automated. They already have those names in their score sheet. We're going to have the coaches just indicate that they're defense coach, government coach, etc. As the tournament gets closer, we may be a little more specific about your naming on screen. We've increased the direct examination time to 9 minutes because things are just a little slower when you use Zoom, because you got to wait to make sure the person's done speaking. We don't want you to lose time on your direct for that reason. This year's case is also a little more complicated than the last couple of years. We figure the addition of a second chair and an extra set of eyes means that you can handle something a little harder. So we want to make sure you have enough time on direct examination to handle it. Witnesses sit while testifying. Attorneys, that's your choice. You'll notice in a lot of instances in these rules, we've not overly legislated how you're going to do things. We haven't told you what technology to use. We haven't told you how to share your screen or when. We haven't told you whether to sit or stand, because we want you to be able to make those strategic decisions for yourself. Online trial advocacy is an emerging field, and I think lawyers in real life get to decide how they want to present themselves. We're giving you that same option. That said, we're certainly going to give you advice on what we found to work, but we're not going to restrict anybody if you want to try something different. So I'll pause here. Any questions so far on the issues we've covered? Great. Demonstrative aids are permitted as long as they do not create material facts. In other words, oh, great question from Ms. Lester. Will sitting or standing hurt the score?
So, could you tell me how this?
Yeah. Go ahead, Patsy. Okay.
You want me to say it out loud?
Sure.
I just wondered, what the judge's perception of that is. Will they say, oh, they're sitting down, they're not standing up? And are you going to be giving any guidance in that in terms of judge training, or, what's the story?
Great question. So I think there's 2 parts to that question. First, are we going to give any instruction there? And the answer is no, because I don't want to substitute my judgment for the judge's judgment. If you have judges, some of them may prefer standing, some of them may prefer sitting. And you might think, well, that's not fair. Well, judges have different opinions all the time. Some judges want theatrical performance, some don't. Some judges want you to look at the jury a lot, some don't. And so we're not going to try to prescribe to the judges how they ought to view the trial and what they find persuasive. That said, I can tell you my experience coaching students in online competitions. I've had my students stand for examinations and speeches. In other words, the scored performances, we've had them stand. When it's been making objections or preliminary matters, things like that, or introductions at the beginning of trial, we've had our students sit. So I wouldn't stand up every time I'm going to do an objection, because then you got to change the camera view, and that's awkward. So my advice is going to be to stand for scored functions like your exams and your speeches, and sit at all other times. I've also seen some people decide they want to sit for direct because it makes it more conversational, and stand for cross. I don't think there's anything wrong with that. I think that's a fine way to go about it. But those are things I would say are strategic decisions. Does that answer the question?
Yes, thanks.
Hey, Mr. Bernstein.
Yes.
Oh, I had a question. You said we have 3 rooms per school, I guess, to do your coach, second chair, and then you as an attorney yourself. Are we allowed to be like in the same physical room as our second chair, or do we have to keep it via Zoom?
There is nothing, great question. There's nothing in the rules that prohibits you from being in the same physical, real life space as somebody else. So, Anna, what's your second chair's name?
Isabella.
Okay, so you and Isabella could be in the same room in the competition. That's totally fine. You can be on the same camera screen if you want to. You may have up to 3 Zooms in our Zoom meeting. Okay.
Okay.
And you can't say, "Oh, we're going to share one, so now my mom can have the third." No, it's one for the second chair, one for the advocate, our gladiator, and then one for a coach. The coach can be anybody you want. The coach can be a parent, a grandparent, whatever. Now, some people might say, "Oh, it's an advantage to be able to be in the same room as a second chair." I suppose I personally would not recommend ever being on camera with the second chair. And the reason I say I wouldn't share a camera is, and this is something we'll talk about more when we do our advice session, the biggest thing you got to worry about is keeping the judge's attention on Zoom. And if they have any distractions, whether they're books in a library or a mug in front of you or another human being right next to you, that draws attention away from you and you're the one getting the score. So I wouldn't recommend it, but you're allowed to do it. Does that make sense?
Okay. Yeah.
Okay, so demonstrative aids, you're allowed to make them. You can show them to us ahead of time. We have the deadline to submit those, and you can be creative in that regard. One of the advantages, I think, of an online competition is that you can do a lot more with exhibits. You're going to see that this year's case has a lot more exhibits, so that way you can use them. It will have photo exhibits, it will have maps, it will have videos, and you'll be able to use those in trial in ways that you wouldn't in a regular courtroom. You'll see that for Rule 7, D7, for purpose of authentication, impeachment, refreshment, recollection, you can assume that the attorneys, witnesses, and presiding judges have electronic notebooks. So we're going to give them a folder with all the exhibits numbered. So that way when you say, "I'm looking at Exhibit 7, witness, can you open that up?" the presiding judge can do it too. Our jurors, that is our non-presiding judges, will not be given that electronic notebook. If they want to look at it, they can, but we're not going to send it to them before trial and say, "Hey, this is material to review." That way, you know that if you want the jury to see something, if you want to be guaranteed that the jury is seeing something, you have to publish it, just like you would in real life. Except here, you're going to do it probably by sharing your screen. You are allowed to hold up a paper copy, but that would be an awkward way, I think, of using it on Zoom. We're going to recommend that you share your screen. Any questions about sharing exhibits, screen shares, impeachment, refreshment, or recollection, anything like that?
I have a brief question about impeachment.
Go ahead.
How much corroboration do we need with the witness that I suppose they are familiar with their affidavit? Do we just say, "You wrote an affidavit," or do we have to go through the normal procedure?
I would say that that is a strategy question. I don't think that is affected by Zoom. Now, one advantage you have with Zoom when it comes to impeachments is, in theory, you could put up, I mean, unless the judge is going to think it's objectionable, you could put up the document that shows a contradiction. You could say, you said one thing, but here's an email you wrote that's in evidence, and you can just put it on screen. Your second chair can literally highlight the words that are contradictory. So you have more tools at your disposal to show a contradiction. But your question is, as far as a litany of questions that you ask to demonstrate foundation, do you just say you made a witness statement, or do you ask 7 questions? That's up to you. You may want to be efficient, or you may want to show off that you know how to do an impeachment. That's your call. Great question from Jeffrey. Jeffrey, do you want to explain the question?
Yes, I'm a coach for one, and I'm new to the competition. And I guess the question is, in reviewing it My question was, it identifies that during trials in which, and again, I'm referring to page 8, Rule E3, when it talks about an E2 and E3, and it talks about during trials in which gladiator competes as a witness. Okay, the second chair may participate in the pretrial, etc., but may not assist or communicate with the gladiator after the trial begins. So it's their witness cannot talk to their gladiator because essentially they are not participating in the trial at all. Is that, maybe I just misread that. Perhaps you can clarify that for me.
Great. And first, Jeffrey, welcome to the competition. We're thrilled to have you a gladiator this year.
Okay, Ms. Johnson and I met at Empire a while back, and Sue, it's so good to see you.
Everybody likes Sue. That's why I'm hoping that people's like for Sue will somehow be contagious and they'll like me, but Sue's the best. So to draw a distinction between E2 and E3, it's because every trial has more than 2 second chairs. So let's forget the defense for a second, just focus on the prosecution. Suppose that, and again, I'll just look at the folks on my screen. Suppose that Zoya, am I saying your name right? Can you nod if I'm pronouncing it right? Awesome. Suppose that Zoya is the prosecutor and Linnea, is it Linnea or Linnea? The first one, Linnea. Okay. So Zoya is directing Linnea as the witness. Each of them has a second chair. What rules E2 and E3 are saying is that Zoya's second chair is the second chair for that trial, for the prosecution. Linnea's second chair, when she's a witness, doesn't have a role in trial. In other words, only the attorney's second chair can be screen sharing, communicating, displaying, etc. Only
that's what I thought. I didn't mean to interrupt, but that's what I thought. I just wanted to make sure that the second chair, when the gladiator is acting as a witness, gets out of the way.
You're exactly right, and I'm glad you clarified.
All right, thank you very much.
Thank you. Ryan Smith says, will the clock run during the publishing of documents to the jury? Absolutely, just like it would in Realtor. And if it seems like that's unfair, I'd say it's actually faster to publish exhibits by screen than to walk back to your counsel table, hand it to a jury, or to put up an enlargement, turn it around. This is faster. I think you're going to find that if you practice, and that's a key if you really practice with your second chair sharing exhibits in real time, you can display and communicate information more quickly and more persuasively through exhibits on Zoom than you can in real life. Also, we've added an extra minute for direct, so you'll be able to share your materials. Okay. One or two of our competitors don't have second chairs right now, and that number could decrease. People could find second chairs, or some people's second chairs could get sick or be unavailable for the weekend. So what we're asking everybody to do is, if the attorney for the round doesn't have a second chair is available and the witness does, we're going to ask that the witness's second chair jump in and help out and show the sort of nobility that we're looking for with our nobility award at the end of the competition. We're going to have an award for best second chair because we like giving out awards when people do great stuff. So let's talk about using your audio and your video during trial. So attorneys, we'll start with the folks who are attorneys. You're always going to have your video on. You're always, and I'll come back to Liam's good question in a second. You're always going to have your video on, and your audio will be on when you're performing. So if it's your direct, your cross, your opening, your closing, you should have your audio on. The reason why we don't want you to have your audio on when somebody else is performing is because of the way that Zoom works. Because you might think, well, I want to be able to make my objection immediately, and that's true. So you'll have to unmute your audio to make an objection. But here's why we want to make sure you have your audio off, is that if the judges are using speaker view, the camera view will switch to whoever is speaking or making noise. But if somebody rustles paper in the background, that will actually change the camera view for the judges, and it'll potentially distract them from the person who's speaking. And so if you want to make an objection, if you want to interject, if there's something that you need to do, then you need to unmute your video to do that. Liam asks, going back to the question of timing, why has cross not been extended? And the biggest reason is actually just logistical. We didn't want to lengthen the trials too much. We want to make sure we're able to run on schedule. And we felt like, given the experience in the past, this was enough time for cross-examination. Witnesses, you're going to mute your audio and stop your video unless you're testifying. So what does that mean? It means that at any given moment in trial, you'll have at most 4 video rectangles on your screen, 4 videos present on everybody's screen. The presiding judge, the direct examiner, the cross-examiner, and the witness. That's it. So the coaches, we won't see them. Second chairs, we won't see them. Scoring judges, we won't see them. And the reason is not that we don't want people to get their 15 minutes of fame. It's that we want to make sure that the judges who are scoring are seeing the people they need to see. And so we don't want anybody else on screen. Good question. If objections come late because of issues with pausing audio, do they still count? Yes. I mean, one of the things we tell our judges is be mindful that this is Zoom. People have to pause half a second to unmute their audio. I can tell you now, having seen these competitions, it's not an issue. It's one of those things that you worry about until you do it, and then you realize you're fine. People are really understanding about the idea that things can't happen as quickly when you're using Zoom. Okay, so coaches are always going to be muted on audio and video. Do we keep our cameras on for opposing counsel speech? Yes, the attorney should keep the camera on, but we're going to encourage the judges to use speaker view for speeches, so only the performing attorney is on screen. Now, the reason I say encourage is we can't force them to use any particular view. We can't make them use side-by-side mode for viewing exhibits. We can't make them use gallery or speaker view when attorneys are performing. So we're encouraging it, strongly encouraging it, but we can't make them do it. That's one reason why we say mute your audio, but don't mute your video. Okay, any other questions about muting and unmuting the audio? Good question. Talia, a returning Gladiator, would you share the question you just asked me? I think it's a good one.
Yeah, I asked if, hi, I'm Talia, I'm from San Diego, California, but I asked if we should introduce our second chair during introductions, and whether that was a stylistic preference, and if we do introduce them or have them introduce themselves, should they turn on their video and audio for that?
That's totally up to you. So I'm glad you asked. We didn't put that in the rules, but if you, as part of your introductions, want your second chair to introduce themselves by audio, by video, by both, that's perfectly fine. But once the trial starts and we're actually seeing performances, that's when we want to make sure that the only people on screen are the ones getting scored. Does that answer the question, Talia?
Yeah, it does. Thank you so much.
And welcome back. Okay. So, timekeeping. So this goes back to Jeffrey's really good question earlier about the distinction between the attorney's second chairs and the witness's second chairs. The attorney's second chairs, the 2 of them, are going to be responsible for timekeeping. And they should communicate with each other during the round. They can do it with private chat. They can do it with cell phones, whatever they want to do to communicate. They can become Facebook friends and chat via Facebook. That's all fine. But they should double check after each part of the trial how much time remains, particularly with the exams, because how much time do you have left for redirect and so forth. If you're going to share that information with the court, we ask you to do it by chat. So that way everybody can see, here's how much time is remaining, et cetera. If somebody's gone over, the presiding judge will say, okay, you can stop. But we're gonna ask everybody to use the chat to share that with the court. Any questions on timekeeping? Great, okay. Communication restrictions. So let's break it down. We'll start with the coaches. The coaches should think of the round starting at the minute the witness prep begins. And once witness prep's over, once witness prep begins, they can't communicate with their gladiators and second chairs until after the trial's over. So that's a black and white rule when it comes to no communication. The second chair for the witness can communicate with their witness up through the end of witness prep. So you're welcome to be involved with witness prep. I want everybody to get to know each other. So that's perfectly allowed. Once that's over, they're sort of back in the dugout with the coach, no communication. And then the second chair for the attorney has no communication restrictions. You can be BFFs forever, chat all trial, it's all good. Okay. Any questions on communication restrictions? Fantastic. All right. The trials end when the judges announce that all the ballots have submitted. That's when they'll start giving the comments, and we'll be doing electronic ballots. I'll send everybody an example of what those ballots look like so you can actually see how the ballots work. Technical issues. We've talked about the number of people who can be in the Zoom room. It's inevitable that somebody's going to have an internet interruption. If it's momentary, if it's just a pause, if it's a lag, let it go. The judges aren't going to swear you down because they didn't hear a word, or if they didn't hear something, they'll say, can you say that again? If there's a significant technical problem, if you get booted out of the courtroom, don't worry, we're not going to continue the trial without both attorneys present. That would seem to be problematic in real life and certainly problematic in a trial competition. So we will get that squared away. We've got a decent amount of time in between each round for that reason. Notify me and Sue Johnson immediately if that happens, and we'll get it figured out. We're going to ask the judges not to submit their ballots if, for whatever reason, they don't think they can compare the two gladiators in every category. So if a judge hears only one closing, the judge shouldn't be submitting a ballot, and we're not going to accept that judge's ballot. If the judge misses 10 seconds or one question of a direct examination, we're not going to tell them they can't count their ballot. That's why they have to be able to meaningfully compare the two attorneys and the two witnesses in every category. If they can, we want their ballot. If they can't, we don't. Someone says, if there's a major issue, how should we contact me or Sue? You're going to have our cell phone numbers. You're going to have our emails. We'll be checking both. I'd say cell's probably the best way to in an emergency, and you'll have all that information. Okay. Will judges not sending a ballot affect our overall score? Good question, Anna. So the answer is no, because we do scoring by average. So that means that it's the number of average check marks you get per judge in your trial. So if one trial has 4 judges, another has 5, some competitions will say, okay, we're not going to count the 5th ballot. We want as much data as possible. What that means is we just take the average from each trial. Okay. The way that Zoom's set up, how will competitors get their scores after each trial? Great question. And then Talia said, will there be open tabulation? So normally, Gladiator has a really open tab room. That means that unlike some competitions where you have to wait till the end of the competition to find out how you did, or maybe you never get your ballots back, we don't do that. Nor do we say, okay, we're going to close the room and you don't get to see anything until we post the results. They're coming electronically, so we do have to then take the numbers and put them into the score sheets, so that way they're readable, because the judges' ballots are just going to look like lines in a spreadsheet. But we do want to give you your information as soon as possible. So literally as soon as we have moved them from raw numbers to totals, that'll be visible to you. It's going to be fully open tab. What we plan to do is give those to the coaches. The coach for each team can decide whether they want, and the team can decide whether they want the students to see them. I know some competitors and some coaches and gladiators are fully transparent, and the gladiator sees everything, and others say, you know, I just want the coach to know. And so we're going to send it to the coaches and parents, and they can decide whether they want to distribute it to their gladiators. And if anybody has any questions about that, just let me know. But we plan to make the data and results available to you within, I don't know, 10 to 15 minutes of the round ending, sooner if we can do it. Other miscellany here, the electronic ballots, obviously we're not using paper ballots. That'd be a very slow way of doing things. If everybody put your ballot in the mail and just send it out. We're not using distance traveled, since we're all in the same place, which is our living rooms. And I jokingly said, do whatever you like with the furniture, because it's not a courthouse. So I'll pause there and say, are there any questions that people have about the online aspect of the competition? And then we'll talk about broader things that are unrelated to the fact that the event is online. Any questions that we haven't talked about for the fact that this is an online event?
I had another question, sorry. So personally, like my school district, we didn't use Zoom during all the coronavirus stuff. So how are ways to I guess, like practice, like you said, with your second chair to make sure you can get all the screen sharing and stuff down?
So, and I don't think you're going to be at that big of a disadvantage, because even people who have used Zoom haven't used it for competition purposes very much.
Mm-hmm.
So I'll use myself as an example. I teach at UCLA Law School, and when the pandemic struck, almost immediately the law school went fully online, and I taught my classes online for the last month and a half of school. I felt like I was pretty good at using Zoom as an application. And then my students and I started to prepare for an online trial competition. I thought, I know how to do this. And I realized pretty quickly there's a big difference. So even if some of your peers have used Zoom more than you have because they've used it for school, they're back to the drawing board figuring out how to use Zoom competitively.
Okay, yeah.
How do you do that? The answer is you practice. You have Zoom, obviously. I know you're using it because you're using it right now.
Yeah.
You got to figure out what your setup is going to be, and I'll talk in a moment about a recommended setup. But you're going to then practice sharing your screen. So I got together, we weren't in the same place, but my students and I had practice sessions of Zoom where I'd send them exhibits and I'd say, okay, do a direct examination. And then I'd give them feedback afterwards about how they shared the exhibits, whether they were quick enough, whether they were using, whether they were zooming in, enlarging the exhibit right, whether they're annotating it right. We talked about where you should stand, where your eye contact should be, and we got better at it. So I think part of your practice for Gladiator this year is Zoom practice, not just mock trial practice. Does that make sense?
Okay. Yeah. Thanks.
Mm-hmm. Other questions?
Justin?
Yeah.
Yeah, I had a question I just sent in the chat. Will all the tabbing and pairing still work the same way aside from just the logistics of having online ballots?
What do you mean?
I mean, the rounds will be paired exactly the same way as before.
Yes.
Okay.
My guess is that this will actually lead to you getting more data about how you're doing, not less, because the way I've set up the tab, we do a similar competition for the college students, and so I set up the tab summary for that, and it's much more detailed because it's a spreadsheet, and so everything just aggregates. So I expect to be able to give you a lot more data about which check marks you're winning, which check marks you're not winning, and so forth.
Okay.
Yeah, the pairing procedure is the same. Sue and I may be a little slower the first time we do pairing round 3 because we've never done it online before. We've never done it where she and I aren't in the same place. But I'm guessing that even online, she'll correct my errors, and we'll move pretty fast. TC asked a really good question. TC, would you share your question with the group?
Yeah, so I was wondering if we're allowed to have physical demonstratives. For example, if during a statement you have like this poster board with pictures and you just point at it.
You can, but I think you're going to find that it's more effective to use your screen share than using the physical exhibits, because when you get comfortable with the screen share, you can zoom in on it, no pun intended, and enlarge a portion of it. You can highlight parts that are really helpful. That's going to be easier than you putting it in front of your screen. Then people, for example, if I were to hold a piece of paper right now, you wouldn't see it as well as if I displayed a PDF on your screen. But there's absolutely no problem with doing it. If you do your practice and think, you know what, he's wrong, I want to use a paper copy, you're absolutely welcome to. Brooke, that's a great question. Would you share your question with the group?
I was just saying, like, if we're sharing our screens, would we share our screens, or would our second chair share their screen? Because I know, like, with Zoom, if you're on that speaker view and someone shares their screen, it like completely takes over the entire screen.
It's a good question. So first, under the rules, either is allowed. You can share your screen, or you can have your second chair share their screen. As far as taking over the screen, you're absolutely right. And I guess I'd say two things. Number one, it actually doesn't really make a difference whether you share it or your second chair shares it. Either way, if it's in presentation view, that's going to take over the whole screen. I'll use an example right now. So I'll share my screen. Okay, so I'm guessing, and you all can tell me, nod your heads if I'm right, that this is now taking up a lot of your screen and my image is now really small. Is that right? Nod your heads if that's true. Okay, but you can actually improve that, and I'm going to encourage the judges to improve that. So here's what I want you all to do. This will work if you're on your laptop or desktop. It will not work if you're on an iPad or an iPhone or a phone, which is why we're telling judges don't use tablets or phone, use laptops. So if you're on a laptop, I want you to try the following with me. At the top of your screen, it should say View Options. Right next to where it says Justin Bernstein is sharing the screen at the top, it should say View Options. And there's a little caret right next to the word Options. Click that downward caret. Victoria's nodding. She's my translator here. Victoria, give me a thumbs up if that makes sense. Great. So when you click that caret, the last option should say side-by-side mode. Click that. Okay, so as soon as you do that, now my picture should take up a little more room than it did before, but we can actually make it better still. You see between the enlargement of my rule book and the photos, there's a little gray line, a little vertical line between those. Click that and drag it to the center of your screen. If you did that right, now we've made my image bigger and the image of your peers bigger, and we've made that screen share a little smaller. We're going to encourage the judges to do that, so that's a better way we think to view the evidence. Now, I'm going to stop sharing it for a second. We go back to regular, and if I screen share again, it should revert to what we just did, which is having the split screen side by side. So we're going to encourage our judges to make that change before they judge, so that way it happens automatically during the trials. Now, are they going to do that? Some of them will, but as you know, judges are stubborn folks, and so some of them won't. But we think that's going to greatly improve the ability for them to see the exhibit and to see you at the same time. Other questions? Brooke, did that answer your question?
Yes, it did. Thank you.
Sure. Okay.
So when someone shares their screen, only the attorneys, second chairs, and the judges see it, right? The scorers don't see it, or?
Everybody sees it. So just because your video is off doesn't mean you don't see the screen.
Okay. Well, my question is because we're not, the students aren't supposed to publish the document to the jury. So how do they share the screen without publishing it to the jury?
They shouldn't be publishing until the document's been admitted into evidence.
Okay, so they shouldn't share their screen until it's in.
That would be my recommendation under the rules of evidence. That's an evidentiary.
Okay, well, just under these circumstances, I wasn't sure how that worked. Okay, thanks.
So I'll give you an example of how I had my student authenticate an exhibit. And we'll do this in more detail when we do our longer session on advice, but it would go something like this. I'd say, if I'm the attorney and Caitlin Rice is my witness, hey Caitlin, all the way from New York. She's our first ever gladiator from New York. I say, Caitlin, do you have exhibit 3 in your notebook in front of you?
And I'd answer yes.
I want you to open it and look up at the camera when you have it open.
Okay.
Great. Is this a fair and accurate copy of the letter that you wrote to the defendant?
Yes, yes, it is.
Your Honor, Judge Lester, we offer into evidence exhibit 3. Judge Lester rules.
Any objections? All right, received into evidence as exhibit 3.
Okay, in evidence, and now I'd say to my second chair, Ms. Akins, would you mind sharing that with the jury? And she put it up on the screen, and there we go.
I understand, thank you.
Sure. Other questions, either about the online or anything else? Okay, so Abby Davis. Abby, would you share this question with everybody?
So my question is, if we are publishing an exhibit to the jury and we want the non-scoring judges to be able to hang on to it and refer back to it, basically the way you'd like hand out real copies in an in-person trial, is there a way that they can still reference it?
I don't think there's a realistic way to do that. I mean, I think we could probably find some Dropbox type thing to give them or something like that. But I think that solution, any solution we have, probably creates more problems than it solves. So I'm going to say no.
Makes sense.
Okay, got a question here. Sam, would you share the question that you asked me with the group?
Sure. I noticed some slight alterations to the ballot this year, and I was wondering if Mr. Bernstein could go over those changes and the reasoning behind them.
Sure. Sam is our first gladiator from New Hampshire. Welcome back. So, Sam, why don't you be more specific? Which changes did you notice on the ballot this year?
I noticed a switch on the attorney side from, I believe, improvisation to theme and theory, and for witnesses from direct examination and cross-examination to engagement and realism. And I was especially curious about those witness changes.
Sure. So the attorney categories we change with some frequency. There's 5 that are always the same: direct, cross, open, close, and objections. And then we rotate the others. We've used improvisation, public speaking, use of exhibits, theory and theme. We rotate it depending on what we want to emphasize and what the case is about. The witnesses, Sam noticed, is a much bigger change from the past years. Usually we use direct, cross, and credibility. And we found that cross and credibility sort of got blended. The judges sort of counted it as the same thing. So we decided to emphasize different aspects this year and try it out. When I did some practice rounds, it seemed to go better. The judges had an easier time differentiating those different attributes. So what I'll tell the judges is that realism relates to authenticity. How real does this witness come across? Do they seem like a real person? Engagement is, are they engaging the audience? Do they have performance skills, public speaking skills, attention grabbing skills that make you want to listen to what they have to say? Now, those two things sometimes are in tension, right? You've got the desire to be real and the desire to be dramatic, and they can pull in opposite directions. And we view that as a good thing because the best witnesses are those who can do both. And the final category is credibility. What I tell the judges is that credibility refers not to how the character is written, but how it's portrayed. The example I use is, suppose you have a witness who is a doctor with a perfect record, and you have, on the other hand, somebody who's been convicted of perjury. That does not mean that the first person gets the check mark for credibility. It's about whether the student portraying the role is responsive to the questions, whether she knows her witness statement, whether she seems unnecessarily biased, if she's always fighting on cross. Those are the kinds of things that we tell the judges to look for when they assess credibility. Sam, does that answer your question?
Yes, it does. Thank you.
Sure. Other questions? Okay. Here's what I'm going to suggest. I know that when you get your case problem and you start actually working through it and you start practicing on Zoom, you're going to have different questions about the rules than the ones you had now. You'll have additional questions. So I guess I'll do a quick poll. By show of hands, how many of you have already begun practicing on Zoom a little bit? Like how you're going to do a trial? Okay. How many of you have not practiced on Zoom as a trial attorney at all yet? Okay. So it's about 40-60. I suspect you'll have more questions when you start getting into it. You're also going to have more questions when you get the case. That's great. I'll get those questions, and those questions will get answered on the Q&A document in your Google tournament folder. We're also going to do, as I mentioned, a session on online advocacy. How many of you think it would be helpful to hear from other people who either coached or competed in events like this? Raise your hand. Okay, so 1, 2, 3, all of you. Okay, great. It'd be helpful for me, and this isn't a requirement, but if there's questions that you have that you want that panel to answer, shoot them to me ahead of time. We'll build it into the presentation. You'll have a chance to ask questions live, but this way we'll make sure we cover in depth things that are on your mind. Okay? Well, it looks like there's no other questions, so I will say good night, and I hope you like the case on Tuesday. I'll give you one hint about the case. Anybody who knows my cases and knows me knows I like television. So this year's case if you watch any TV, if you stream any television, you may be familiar with the premise. So you'll get it on Tuesday. Good luck, and thanks everybody for joining. Good night.
Thank you.
Hey Ryan, nice to see you. Thanks for joining.
Definitely. Thanks for doing this. It's awesome.
Yeah, I'm glad your students participating.
Yeah, for sure. We're very excited to be here.
Very cool. Well, have a good night.
You too. Thanks.
I will unmute. That was good. So it's interesting to hear how you answer the questions and what they ask. So that was really good.
Anything you think I could or should have done better?
No, I mean, really, I think I thought it was great to have them go ahead and practice the split screen thing so that they would know what that looked like. I was hoping you would do that. And I think the addition of a tips session with people that have done it is going to be really super helpful. So yeah, I don't think you missed anything. I thought that was great. So
I wanted them to talk to try to like make it more, not only to make it more interesting, but I wanted them to start to get the experience of feeling like they're not just being lectured at and like they're involved. You know what I mean?
yeah. Yeah, it's good to have them read it out loud or follow up on what they were trying to ask and everything. So
yeah,
that's good. Cool.
Yeah, I mean, I wanted to send, the line I was trying to walk was, we know how to use Zoom better than you guys do. Not like in an arrogant way, but like we've thought about this.
Right.
And without being too pushy. Do you think that we got there?
Yeah, I think so.
Okay.
Yeah, gave them confidence that it'll go smoothly. So
yeah.
Yeah.
Cool. Thank you so much.
Yeah, I guess I'll see you again, tomorrow or whenever, Saturday. Long weekend. It'll be great. All right. See ya.